Thank you for joining us for today's webinar, Employment Law, the Basics, What You Need to Know to Stay Out of Trouble. A major step in the growth of your business is the day you hire your first employee. Passing this threshold, you enter a whole new world of laws and regulations at both federal and state levels, which require compliance. Today's program is designed to provide you with information on the most frequent legal, compliance issues encountered by small business owners in managing their employee relations. First, let's meet our presenters. Greg Keeson serves as the Moore Norman Technology Center Business Development Center Coordinator. Greg's multinational experience background spans over 30 years in corporate executive management as well as management of his own business. As the manager for Moore Norman's award-winning and nationally certified business incubator, Greg has helped develop a number of new ventures from start to finish. Greg has the ability to coach entrepreneurs towards creating, running, and growing successful business. Rob Norman is an employment law attorney with the firm of Cheek and Falcone in Oklahoma City and is a resident of Norman. Rob has been practicing employment law for over 22 years as a litigator and advisor to business previously with the McKinney and Stringer law firm in Oklahoma City. Rob also serves on the advisory board here at Moore Norman's Business Development Center. Join me in welcoming Rob Norman and Greg Keeson.
Hello and welcome to the webinar. This is Greg Keeson. Before we turn over the microphone and the presentation to Rob Norman, our employment law attorney, I wanted to go through a couple things relative to our presentation today. It's going to be focused initially on Rob's presentation on employment law, and then I want to take some time at the end to tell you about the services here at Moore Norman Technologies Business Development Center. Let me also mention on a personal note that I've known Rob and have worked with Rob during my business career over a period of about 15 years, and he is one of the finest employment professionals that I have met in my career. So with that, let me turn it over to Rob Norman for a discussion of employment law, the basics.
Thank you, Greg. At the outset of talking about these kind of things, I always like to get to the why first. Why be a part of this webinar and why comply? And what I'd like to talk about is some specifics. What you're going to learn today as we go through this are some specific compliance issues that will help you reduce unemployment claims. For example, ways that you can incorporate material into an employee handbook that will help you prevail on an unemployment claim. Whereas if you didn't have that material on your employee handbook, you probably wouldn't prevail. Same thing. You can reduce workers' compensation claims in the same way by having certain policies and procedures in relation to safety, drug testing, things like that, that if you adopt them and implement them, you can help reduce your workers' compensation claims. Third, avoid costly lawsuits. Of course, nobody wants to be sued, and what I always say in my practice, which is primarily focused in this area on representing business owners, businesses, and management, is once you get sued, if you can't get out of it right away, you've already lost the lawsuit. Even if you win the lawsuit in the end, it is an economic drain. Litigation is not your profit center. You need to adopt policies and procedures, and you need to comply with all these myriad of employment laws in order to avoid getting yourself in a claims or litigation situation in the first place. Because even if you win the lawsuit, you've spent thousands, tens of thousands, maybe hundreds of thousands of dollars to prove your point. And in business, we don't consider that a victory, even if you win in court. So in other words, you're going to have a more profitable business if you know about and you comply with employment law. And this really applies in Oklahoma to all business owners, small, medium, and large. Employment law is sometimes known as a game of alphabet soup, and across the nation among practitioners of employment law, it's also known as a game of numbers. Many of the things that a business owner could have a claim filed against them for in the way of employment law and employment discrimination in Oklahoma used to have to do with your number of employees. 15 employees for things like race and gender, 20 employees for things like age, 50 employees for things like the Family and Medical Leave Act. Well, now in Oklahoma, for most types of employment discrimination, the employee threshold is 1. In other words, in Oklahoma, all those things you may have heard about as a small business owner, if I don't have 15, if I don't have 20 employees, I don't have to comply, are no longer true. There's still those 50 employee thresholds for the Family and Medical Leave Act. Obviously, you may have heard about for health care reform. But in the arena of things like disability discrimination, age discrimination, gender discrimination, national origin discrimination, race discrimination, the number now is 1. There are none of those thresholds. So even the small business owner needs to be paying attention and adopting these policy procedures and complying with these employment laws that we're going to talk about today. Now, the first substantive or topic that we're going to talk about is the employee versus independent contractor issue. And this has become a hot button issue in the Obama administration with the IRS, with various federal agencies such as the National Labor Relations Board. And the thing I always run into is frequently, on a weekly basis, I run into folks and business owners who are operating under the radar screen or are operating in an industry where things have always been done a certain way. What I'm talking about here, to put it simply, is whether the people doing work for you is classified as employees or independent contractors. To put it even more simply, are there people that you're keeping a record of with the IRS through W-2s or 1099s? There's some folks that have always had certain workers run through as so-called 1099 independent contractors. Some other types of workers run through as W-2 employees. The problem today is the federal and state governments more and more, out of a desire to get more revenue, out of a desire to crack down on those who they deem to be running under the radar screen, are wanting to have more and more workers classified as employees rather than independent contractors. So if you as a business owner misclassify a worker, you can get into big trouble. Generally what you're talking about is big financial trouble. An independent contractor, you may know, you're not withholding payroll taxes from. You're not making Medicare contributions for. You're not making Social Security contributions for. You're not keeping workers' compensation insurance on them. You're not making unemployment compensation premiums or tax payments on. If they're an employee, you're doing all these things. And if the government decides that you have classified someone as an independent contractor, should have classified them as an employee, this can be a major, major, major liability for you. Now, how do you tell the difference? Well, unfortunately, it's not easy. And it's not always just a matter of, this is the way we've always done things in the industry, so it's not going to come at us. The biggest example that's real topical right now as we're doing this webinar is the Northwestern University case. We all know ever since the start of college footballdom and NCAA college athletics that what happens is a good athlete graduates high school, gets an offer for a scholarship, goes and plays college football, basketball, whatever, and we think of them as an amateur student athlete. And the universities have always treated them as an amateur student athlete. Well, now the National Labor Relations Board has said, no, that's not the case. These folks are professional employees entitled to unionize if they wish. So just because an industry has always done something one way doesn't mean a federal agency is not going to decide, no, we're going to do it another way from here on out. You know, what are the federal agencies looking for? What's the IRS looking for? What's the State Department of Labor looking for in deciding whether your workers are employees or independent contractors? Well, the overarching thing they're looking for is they're kind of looking for your right to control the worker and the degree to which you actually exercise that right to control the worker. In the Northwestern University case, the federal administrative law judge said, hey, the universities have the right to and do control the time and work of these athletes. Therefore, that tells us that they're compensated for their time, but that they're employees. Same thing in many other industries. There are various tests that the courts and the agencies have set up to decide whether someone is an employee or independent contractor. There's 7-part tests, there's 11-part tests, there's 3-part tests, there are 20-part tests. They're all really tests that go on and on and on and on forever and are very fact intensive. But the overarching consensus of these tests has to do with control. What the IRS says is we're going to look at behavioral control, financial control, and the type of relationship. And the IRS goes on, and they're borrowing these from other agencies and courts and things like that. They're saying, what does control mean? Control means, is the business basically controlling the method and manner in which, first, the worker does the work, when and where to do the work, what tools and equipment to use, what workers to hire or assist with the work, where to purchase supplies and services, things like that. They're also going to look at, the agencies and the courts are also going to look at things like, is this worker basically just working for the business owner, or are they legitimately in business for themselves? Is the worker their own company, and do they offer their services to other businesses? Or basically, are you as a business monopolizing 40 hours a week of their time, and they're dependent upon you for a living? That's a sign that the person is an employee instead of an independent contractor. Also, things that can help you as a business owner may be, if you're worrying about whether this person is right on the line, what I would do is I would create written agreements with these folks that basically say things like, hey, we both acknowledge that our relationship is that of independent contractor rather than employer-employee. That'll help. It won't fix the issue, but that'll help. Maybe this worker who's working for you should be in their own business. Maybe they should be incorporated, or maybe they should have their own business entity. That tends to say that they're an independent contractor instead of an employee. What you don't want is you don't want just an individual working for you 40, 50, 60 hours a week using your tools, your equipment, not their own tools, their own equipment, just working at your place of business, dependent upon you for a living, and doing what you tell them to do, and plus you get to tell them when to show up and when to leave. That is going to be an employee. And if you're 1099ing that person, you may find yourself in significant trouble down the line. One of the other consequences of misclassifying a worker as an independent contractor instead of an employee leads me to my next topic, which is overtime. We start with the assumption that an employee of an employer is entitled to time and a half pay for any hours they work in a work week over 40 hours. This is what we call an employee who is non-exempt from overtime. Of course, federal statutes and regulations provide for certain exceptions to that, and a person whom federal law says you don't have to pay overtime to is considered an exempt employee. Now, how do we figure out whether someone is exempt or non-exempt? Well, we have a whole body of federal regulations that talk about the issues. The first thing you have to understand, and that a lot of people make a mistake on, is they hear about this hourly versus salary distinction. I still run into a lot of people in business who think that the difference boils down to whether the employee is paid on an hourly basis or a salaried basis. what they will say to me is, well, this person is not entitled to overtime because I pay them a salary, or I'm paying them overtime because I pay them hourly. Well, that's not really the test. And why is that not really the test? Because if it were, we would all just classify employees and pay them a salary, and we'd never have to pay them any overtime. What really is important is their job functions. And the only place where salary and hourly comes into play is if you pay someone truly on a salary basis, they can be exempt from overtime. In other words, in order to be exempt from overtime, they have to be paid a salary, usually in most cases of at least $455 a week, or about $23,000 a year. If you don't pay them on a salaried basis, it doesn't matter what they do, how important they are. In most cases, they are a person who is going to be entitled to overtime. Now, of course, there are certain exemptions to that rules, but we've got a limited amount of time, and I'm going to kind of stick with hourly and salaried. If you have a salaried worker and you dock them for less than a day's worth of pay for disciplinary reasons or for missing work, the Department of Labor may say you're no longer paying them on a salaried basis and you have to pay them overtime no matter what they're doing. Now, I mentioned job functions as being determinative of whether someone's exempt or not exempt from overtime. And here are kind of the most common exemptions that you may hear about from overtime laws. The most common exemptions that we deal with in business on a day-to-day basis are the administrative, professional, and managerial exemptions. The administrative exemption is often the hardest one to deal with in practice, because this is a case, again, where a lot of people want to call someone an administrative assistant, an office manager, a legal assistant in my profession, put them on a salary, and not pay them overtime. That won't cut it. The administrative exemption is the hardest thing to deal with, because usually when we think of people doing administrative work, we tend to have those people doing clerical work, filing work, answering phones, maybe doing a little bit of scheduling for someone, doing secretarial work. And that's not what we mean by an administrative assistant or an office manager exempt under the administrative exemption. When you're thinking of who is exempt under the administrative exemption, think of someone who would, say, be more of a chief of staff for the boss. In other words, what is important is, does this administrative person exercise considerable discretion and independent judgment in their work? Do they really do the scheduling for the boss from start to finish? Do they control access to the boss from start to finish? Do they have discretion in how the office is operated and how the office is run? That might be a person who is exempt as an administrative person from overtime, as opposed to a clerk or a secretary, or even, say, a legal assistant in the legal profession who is not exempt from overtime. The second most common exemption is the managerial exemption. Now, the important part of the managerial exemption to understand is, first, they have to be managing at least 2 people. But it can't be an assistant manager of a 7-Eleven who's in there working by themselves or always just has one other person in there. In fact, some convenience stores have gotten in trouble for that. They have to be managing more than one person. And their primary responsibility has to be management. They have to actually manage the enterprise or a significant part of the enterprise. The third, of course, is the professional exemption. And that is commonly what we think of as, the lawyer, the doctor, the architect, the person with a significant education, the creative artist with a significant education, with a significant exercise, again, of independent judgment and discretion in the performance of their work. But just understand that it doesn't just have to do with whether they're on a salary or not. It has to do with their job functions, and that the hardest one to deal with is the administrative exception from overtime. All right, next topic we're going to talk about is job interviews. We may see on the slide kind of the title for this is the questions not to ask and how to still get the information you need. The problem here is when you're having someone fill out a job application, when you're having someone interview for a job, you want to get important information from them. You want to get to know them. You want to see if they fit the culture of their workplace. But there are certain ways that you cannot do that consistent with the law. What you need to take away from interviewing do's and don'ts is a simple rule of thumb is keep your interviewing questions focused on the essential functions of the job. Before you get in the interview room, hopefully you have a good working job description, a good idea of what this person is going to be doing, and a good idea of what type of person and what type of qualifications and what type of education you need to perform the essential functions of the job. And the rest, in the eyes of the law, is considered to be not only not necessarily relevant, but inquiring into other things in the interview process can be illegal. Now, what is illegal and off limits? Obviously, the obvious things like age, you can't ask how old someone is. That's an obvious no-brainer. You can't ask what their ethnicity is, what their race is, what their national origin is, what their religion is, what their gender is. And believe it or not, that's not always an easy thing to determine just by the eyeball test. But those kinds of things are absolutely off limits in almost all job interview situations. Now, of course, the obvious questions are easy to avoid. How old are you? You know, what's your gender? What's your race? Things like that. But there are some less obvious questions and some less obvious things that you can't do according to the federal regulators like the Equal Employment Opportunity Commission. One thing you have to avoid is getting photographs in the application and interview process, usually. That's something that was once, a generation or two ago, commonly done. Now, getting photographs of applicants is kind of considered to be something that might be used as a screening tool to weed out persons of a certain age or persons of a certain race or color. So avoid that sort of thing. Another hot button issue that's not so obvious is you have to avoid emphasizing, perhaps during the application and interview process, overly emphasizing that this might be an entry-level position. Seems innocuous, but what's the problem with that? Well, if you start talking all about how something is an entry-level position and asking about someone's qualifications in terms of are they an entry-level type worker or not, what's the EEOC going to think you might be doing? Screening out people because of their age. They might. That's a little less obvious and a little less subtle thing, but that's something the EEOC is looking at. You also want to know what someone's educational background is, but what's a no-no to do when you're asking about someone's educational background? What you want to avoid is asking, what year did you graduate from high school? What year did you get your degree? Why? Well, think about it. If you can pinpoint the year someone graduated from high school in the United States, as you're sitting there with your calendar in front of you, you can probably pinpoint their age. And people like the EEOC and the Oklahoma Attorney General's office, who now controls civil rights laws in Oklahoma, are going to say, you might be trying to screen out people because of their age. So, you can talk about educational requirements if they are part of the essential function of the job, but don't start pinning it down to a year they graduated from high school or a year they got a degree. You can't ask someone if they're a citizen of the United States. Why is that? Because that can be considered an effort at national origin discrimination. More and more and more, the law has deemed it to be not relevant whether someone is a citizen. They just need to be someone that once you give a conditional offer of employment to and once you decide you want to hire them, is someone that you can ask for, and you better ask for, through the I-9 process, proof of their eligibility to work in the United States. Some people will say, go ahead and ask them, are they eligible to work in the United States during the application process? I would say don't bother. I would say don't even bother to ask that in the application process. Wait until you get to the point where you hire them or you want to hire them and you're going to do the I-9, and then you go through the process of having them show you their eligibility to work in the United States. So those are kind of some of the more subtle things that you have to watch out for when you are doing interviews. Another hot button issue are arrest and conviction records. If I were an EEOC employee here worrying about compliance with federal civil rights laws, I would tell you not to even ask about convictions during the application process. A lot of people still do. A lot of job applications ask for whether you have been convicted of a felony. That might still be okay as long as the question or the entry on the job application is qualified with the notion of, okay, answering yes won't necessarily disqualify you from employment. But again, probably in this day and age, the better thing to do is wait until you've decided you want to hire this person, you extend a conditional offer of employment to this person, and then if a criminal background check is reasonably related to the qualifications for the job or the essential functions of the job, do a criminal background check. I'm not saying there aren't some potential liability issues that are going to come up there as time goes on, but you're better off saving the conviction question until the point where you get to the point where you want to hire someone and you're just verifying before you put them on the payroll that they aren't a convicted felon or a convicted embezzler as a bank teller or something, for example. But arrests, I would say arrests, the bare fact of an arrest, just stay away from that. Things like that. Just absolutely stay away from that sort of thing. You also can't talk about physical conditions and disabilities, height, weight, injury, medical past, things like that. That, again, is something you can't get to unless you have the type of job that justifies a fitness for duty medical exam. Again, once you decide you want to hire this person, go ahead, and then at that point you can have a fitness for duty medical exam. But don't start asking about disabilities or medical conditions or prior workers' compensation claims, things like that, during the process of asking and interviewing. All right, next topic we'll get to is development of the employee handbook. Some of you who have maybe talked to an old country lawyer 20, 30 years ago, or the lawyer who helps you out with your estate planning 20, 30 years ago or something like that, may remember a conversation along the lines of, you're a small business, don't bother with doing an employee handbook because you don't have to comply with these laws and you may create rights by developing an employee handbook and giving them rights through this employee handbook. Well, that was probably good advice 20, 30 years ago, but it's not necessarily good advice today. As we talked about in the early parts of why comply, every employer now has to comply with these age discrimination laws, with these race discrimination laws, disability discrimination laws, things like that. Every employer in Oklahoma has to be an equal opportunity employer. So you need to have an employee handbook of some kind, whether you're small or large. And it's kind of like Goldilocks and the porridge. You know, if you're a very small employer, you don't need a Family and Medical Leave Act policy for an employer who has 50 or more employees. So you don't need the porridge to be hot, too hot. You don't need the porridge to be too cold and have nothing. You want the porridge to be just right. Have an employee handbook that kind of fits the size of your business. Obviously, if you have 50 or more employees, and it can be part-time employees for the purpose of the Family and Medical Leave Act, you better have a Family and Medical Leave Act policy in an employee handbook. If you don't, there are nevertheless certain employment policies you must have and should have in the way of an employee handbook. You should have an equal employment opportunity policy. You should have an employment at will policy. Very important to get rid of that concern that the country lawyer may have had 30 years ago about creating rights by creating a handbook. You want to make sure that the employee understands and that it's written in a handbook that employment is still at will, even with all these discrimination laws. That unless one of these discrimination laws applies, that employment is terminable or it can be ended at will by the employer or the employee at any time. You want a short disability accommodation policy that shows that you are aware of and complying with the Americans with Disabilities Act that basically says, hey, if you think you have a disability or a problem, come talk to us and we'll talk about how we can work around that and give you a reasonable accommodation and still allow you to do the job. You need an immigration law compliance policy. You need overtime policies, basically that say, and here's kind of what the overtime policy needs to say. It doesn't need to recite and repeat all the laws of overtime, but one of the most important things an overtime policy needs to say is it needs to say, you only work overtime if you have the permission of a supervisor or a certain manager. You are committing misconduct, essentially, if you work overtime without that permission. But the way we will remedy that misconduct is not to not pay you. We're going to pay you if you work the time, whether it was authorized or not, because we have to under federal law. But what we may do is we may write you up, we may engage in some discipline, and if you keep doing it without permission and against our direction, we can terminate you for working unauthorized overtime. That's a very important part of an overtime policy. Workplace conduct policies and progressive discipline. Why is this important? Well, it's important to let the employee know this is what's acceptable and not acceptable in the workplace. That's kind of the human resource answer to that question. The more hard-side legal answer to that question is recently the Oklahoma legislature has for the first time defined what is misconduct for the purposes of a terminated employee being not granted unemployment compensation benefits. In other words, one of the main reasons an employee is not going to get unemployment compensation after being fired is they got fired for misconduct related to the job. Used to be that wasn't defined in the statutes, that wasn't defined in the regulations. It was often just up to whatever the unemployment officer thought it was or whatever the court thought it was. Well, now for the first time, there are set definitions of what is misconduct for the purposes of disqualifying a terminated worker from employment compensation. So it's good to have a handbook that incorporates those concepts in it. If not verbatim, perhaps near verbatim. So that's a reason to get an employee handbook, to put those things in there, and to change your employee handbook if you need to. It's a good idea, whether you are or aren't subject to the Family and Medical Leave Act, to have leave policies that define what vacation, sick leave, jury duty, witness duty, voting time off, other time off someone is entitled to. Another very important thing for small and medium-sized employers is the kind of thing that defines what is property of the company. In other words, inventions, developments, products created by an employee while in the course and scope of their employment are not the property of the employee. They are the property of the employer. And all intellectual property rights are the property of the employee, rather the employer. Other things to have are things like non-disclosure policies, confidentiality of company information, non-solicitation of company customers and company employees, things that protect the employer's intangible sorts of rights and lets the employee know what is and is not a good idea. Another good idea, if you're drug testing at all, you'd better have a written drug testing policy. Used to be I would tell employers, unless you almost have to, don't have a drug testing program. Now the drug testing policies, although you have to have them, in order to prevail on unemployment claims, in order to prevail on workers' compensation claims because an employee failed a drug test. You have to have the policy, but it's a much easier policy to put in place. But you still have to have it. So kind of the takeaway is have the employee handbook, no matter how small or how big you are. You have to have those EEO policies. You have to have an anti-harassment policy, sexual harassment policies. Have a place for employees to go to, a person to go to if employees are having a problem. Don't just say a supervisor or a manager. Say, if you are having a problem with harassment or having a problem in the workplace with such and such problem, you are to report that problem to Greg Keeson as soon as possible. Name a person or name at least the title of a person. Don't leave the employee hanging on what they're supposed to do. And that kind of takes me to the next topic, which is performance evaluations. Once you get this employee on board, you've adopted all these policies, you've trained on these policies and procedures that have to do with compliance of the law, you've trained them on how to do the job. Now, what are you going to do to make sure they're still doing okay? Well, you need to do some type of performance evaluation and get it in writing at least annually. And on the human resources side of it, of course, we always want to accentuate the positive. Where the positive, give credit where credit is due. Give help where help is due. Don't be mean-spirited. Don't do anything that a court or a jury would look at later on and say, this is a bad person who did this performance evaluation. But on the other hand, be very honest about your assessment of this person's performance. And why is that? Well, one of the biggest problems that I get into in representing employers who have a problem with a termination is they come to me and say, well, we've had Joe back working on the line for 5 years and he's just never been any good. And we've had to deal with it and we're finally fed up with it. And we've tried to be nice with him and we've decided we finally got to get rid of him. And my first question back is, well, why did you put up with it for 5 years if it was so bad? And that's going to be the first question of a court or a jury if he files a lawsuit, or the unemployment hearing officer if he files just simply a claim for unemployment compensation. If this person was so bad, if this person was doing all these bad things, why did you put up with it for 5 years, first of all? Now, let me look at this person's file. Were you doing performance evaluations on an annual basis? And do I see a documented trail of how bad this employee was all this time? You know, was this person properly trained? Was this person told that there was this problem going on? Well, if it was going on for 5 years and there's no paper trail of it, there's no performance evaluations, a court is going to say it's up to the jury to decide whether you, the business owner, are telling the truth about why you terminated him, or whether maybe the employee is telling the truth when they say, I think it's because of my race or my age instead. The interesting thing about employment claims is very few of them are obvious cases of discrimination and very few of them are frivolous, cases of obvious non-discrimination. They all kind of fall in the middle, where there's a situation going on where there seems to have been a legitimate reason for the termination. You've got it okay documented or documented in some form, and maybe there's a good story that a supervisor tells about the problem with the employee. But the employee also has a pretty good story too. The employee always thinks, I'm a good person and I'm a good worker. It must have been something else. It wasn't my performance that I got fired for. It couldn't have been. You know, I'm well liked at home. I'm a good dad. I'm a good mom. I've got friends. I do good work. I'm smart. All employees think that. So from their perspective, they start thinking, why was it really that I was fired? Was it something else? Was it something illegal? And lo and behold, they go down to the EEOC or the Department of Labor and file some kind of claim. And when that happens, or before that happens, there better be a good set of documented performance evaluations that show, hey, this employee had problems, they were told of these problems, and they couldn't fix them. Which, of course, leads into a related topic, which is maintaining and documenting the employee file. Obviously, there needs to be a good personnel file for any employee, no matter how small, no matter how big you are, that has, of course, things like these performance evaluations. Are those things in there? Is there a written record of this person's performance? Good, bad, or indifferent? Is there a written record of this person's disciplinary problems, if he had them? Is there a consistent policy and procedure that all employees who engage in a certain disciplinary problem are going to have that placed in writing, are going to have a record of that, and it's going to be placed in an employment file? I mean, the whole crux of the employer being able to do risk management and being able to prevail on a claim against the employee that the employee brings is going to be documentation, documentation, documentation. I would submit that most employers who maintain and document a good employee file that has performance evaluations, that has records of any discipline, that has records of any good milestones going on with the employment process with the employee, that has a good handbook, that has good policies and procedures, that trains on those policies and procedures, that is the type of employer who is rarely, if ever, going to find themselves in court or having a problem if they ever do get to court. The most problematic discrimination claims I have seen, the most problematic harassment claims I have seen, are cases where you don't know if it happened or not, but the employee file might have an application and a W-4 election in it and little else. There is no employee handbook, or there is no good anti-harassment policy in the employee handbook, or if there is a policy in the handbook, it was swiped off the internet and there's no record of this employee ever having been trained on the policy whatsoever.
Rob, let me just add a personal anecdote on that subject, going back to a case that you and I had jointly a number of years ago. You mentioned, maintaining the file. I would mention also that where the file contains information and documentation in terms of performance measurements that are in the file, to make sure indeed that they are accurate and recorded on a timely basis. Because going back to a case that we had, we found, unfortunately, as we moved into the case, that there were some mistakes in the file relative to some performance measures.
Yes. In that case, there was some inaccurately recorded documentation of a certain employee's performance, and it was maybe a page or two of information, and it became the central focus in the case because performance measurement was not accurately documented by a certain supervisor. The whole thing was probably, for that reason alone, going to go to a jury, because it was going to be up to the jury to decide whether the manager had innocuously or innocently just mixed up some numbers going from one report to another to what he wrote down, or whether the manager had manipulated the numbers, hoping that the plaintiff and their attorneys would never get back to the source documents and the source reports from which the information was inaccurately, or from the other perspective, intentionally written down improperly. So yes, accurate, honest, and thorough documentation is important in maintaining and documenting the employee file. Because if there is a document or a story out there somewhere to be told, you can be sure at some point during the claims process someone will tell it. So there needs to be a documented record, and an accurate documented record for a court to get to look at, for a jury to get to look at, and if done properly in the first place, it may never get to that. Which, of course, leads me to kind of the last nuts and bolts substantive topic before we talk about the future of employment law, which is handling disciplinary issues and terminations. We've talked about doing performance evaluations properly. We've talked about documenting the file. Handling disciplinary issues and terminations goes hand in hand with that. When you're handling a disciplinary issue, again, you have to make sure you get a problem nipped in the bud and documented when it happens. Don't let bad employees linger, and don't let bad issues in the workplace linger and fester and multiply and become a problem. If an employee is starting to show signs of unexplained absences or getting to work late when getting to work at 8 o'clock is an essential function of the job, don't let it fester for 6 months. Get to them right away when it starts happening that first, second time and say, hey, what's going on? Are you having problems getting to work? What can we do to help you with that? Document it. Show so-and-so, hopefully you have a good clock-in, clock-out system for your non-exempt employees, a good record-keeping system. But if it's someone who needs to come in at 8 o'clock and they're constantly coming in 20, 30 minutes late, or even some cases it may be 2 minutes late if they have to be at a phone at 8 o'clock for the call that's inevitably going to come every day at 8 a.m. You've got to get with this person in advance of any problem coming up. As soon as a problem starts to come up, you've got to get with them and say, hey, what's the problem? Correct it, document it right away. Do it consistently. Don't play favorites. Because you may think you're playing favorites because someone overall performs better than someone else. But later on, someone looking at what's happened may think, well, are they playing favorites because someone just generally does a better job than Sue? Or are they playing favorites because Bob is a man and Sue is a woman? Is that why Bob didn't get written up for showing up after 8 o'clock and Sue did and eventually fired? You've got to be able to be consistent with determining what's a disciplinary issue and handling it right away. And when it gets to the point of termination, again, obviously with being consistent, you have to handle the termination process right. First of all, don't get into arguments or overly long-winded explanations with the employee about why the termination is taking place. To the extent you do that, be very brief and be very honest, and hopefully your reasons are well documented, and they better be well documented ahead of time, ahead of that termination. You're being terminated because you violated our policy against excessive absenteeism. And of course, we better make sure they're not being absent for medical reasons or reasons related to a disability, or in other words, reasons that might be a federally protected reason. But just be pointed to, hopefully you'll be able to pin it to something going on that's in your employee handbook and something that's been documented already, and be able to say, hey, we're terminating you because you violated our anti-harassment policy. And that's kind of it. Do not let a terminated or a resigned employee linger for 1 hour longer than they need to in the workplace. In other words, if you have a 2-week notice policy, you may have a 2-week notice policy so you can find a replacement. However, is it always a good idea to let an employee give you 2 weeks notice they're quitting and stay around for 2 more weeks? Often it's not. You need to decide how important is it that they stay around for 2 more weeks, and often once you honestly assess that, you're going to make a decision, hey, maybe I need to cut them a check for the next 2 weeks and tell them, go ahead and get your belongings and you don't have to be here after the end of the day today. That's going to be it. We're not going to let you stay around for another 2 weeks. On the other hand, don't overblow it. Don't terminate in a public place. Don't terminate in front of people. Don't bring, if you're just in a fairly low level security, low level privacy office environment, don't have the police or an armed security guard come to escort the employee out in front of everyone else and embarrass them if such security and high-level sensitivity is not an essential part of the termination. That sort of thing can get the employee mad and get them filing embarrassed and get them filing claims against you that they ordinarily wouldn't. So again, be consistent. Be brief in your explanation of the reasons for termination, and you'll find things will go well. Now, a little bit about the future of employment law while I've got you for just the last few minutes. You'll see certain hot-button little issues about where employment law is going. I think employment law in our society in general first is going in a direction that sexual orientation discrimination will be formally illegal. I think most workplaces now kind of either assume that it is illegal or they act as if it is illegal. But I suspect with things like the Defense of Marriage Act cases, the things going on in the states, and the things going on at the federal level, that very soon sexual orientation discrimination will be formally illegal across the United States as well as Oklahoma. Minimum wage increases. I would predict that for the private sector workforce nationwide, there will, within the next couple of years, be a minimum wage increase. It may not be the $3 an hour minimum wage increase that the Obama administration is pushing for, but there will be some sort of incremental minimum wage increase that will happen in the near future. Whether you're going to say that's good or bad, expect a deal to be cut. Expansion of overtime. This will happen. The Obama administration will rewrite federal regulations to allow people who currently are not getting overtime right now to get overtime. In other words, folks who are making, say, between $35,000, $40,000 and are otherwise classified under the regulations as exempt right now aren't getting overtime. That sort of thing is probably going to change. You're going to see people making $35,000, $40,000 a year right now who aren't getting paid overtime, kind of the low-level, the mid-level manager. You're going to see that person in the near future getting overtime. And that is something that is going to be done and can be done without an act of Congress. So just expect that to happen in the next 2 years, whether Congress passes or not. Expanded family and medical leave. Right now, this is something that's going on kind of state by state, experimentally. Places like California have some expanded rights to paid family and medical leave, rights to medical leave beyond 12 weeks. Right now in the federal system, the general rule is if you're a shop with 50 or more employees, your folks, if they've been there for a year and have 1,250 hours of service, have a right to 12 weeks of unpaid family and medical leave for certain reasons. Look to see that expanded as the years go on, state by state, and eventually at the federal level, to be a right to maybe a few more weeks of family and medical leave, maybe some system of paid family and medical leave. That may be further off under the horizon, but expect that to happen, whether you're for it or against it, sometime in the next decade or so.
Well, Rob, thanks very much. It's a tremendous amount of information for those who are listening out there to absorb and understand in a very short period of time. I want to thank you again for your participation and mention to those out there that Rob indeed is a member of our advisory board here at Moore Norman Technologies Business Development Center, as well as providing some counseling services for our clients here in the incubator. Now, while you think about your questions that you might have for Rob or for myself, let me provide you with just a short introduction and some information relative to the Business Development Center. First of all, we are a certified business incubator certified by the Oklahoma Department of Commerce and in association with the National Business Incubator Association. I'm very proud of the fact that in 2013 we received the U.S. Small Business Administration Oklahoma District Business Incubator of the Year Award. And then I want to talk more about our entrepreneurship programs and our advisory services. Let's talk for just a minute about the Business Development Center as a certified business incubator in terms of who are we looking for, what does it take to become a part of our program. We're looking for unique business ventures. Generally, these are people that have some type of unique intellectual property in the way of a patent, a copyright, etc., something that distinguishes them from the general public or businesses that are already competitors in the marketplace. Here, we are a mixed-use facility. We can accommodate office functions, people like software developers, as well as having some light industrial space that can accommodate light manufacturing, assembly, logistics, etc. We have a staff I'm going to talk about in just a minute to provide support and mentoring besides our advisory board. That staff is designed and focused on accelerating the growth of your business, helping you to avoid the common mistakes that new businesses make that cause the failure rate of new businesses to be very high, and to assist you in trying to locate financing for your business. We provide support and encouragement relative to the entrepreneurial efforts and the entrepreneurs in our area to help them to focus, get organized, and to execute their plan. And one of the things we specialize in is helping people to develop their business plans and to articulate all their visions to get started. Our services are available to all local residents and businesses in the Moore-Norman School District, which encompasses the Moore and Norman schools. That is to existing business owners, to entrepreneurs who are trying to define a concept and develop that concept, into inventors who have new products to try to help give them some direction. And lastly, let me talk about our advisory team here, which I'm very proud of. Our job is to help you evaluate who you are, your particular abilities, your particular attributes, your strengths, your weaknesses, to help you towards success. And with the 3 members of our team here, we have over 70 years of combined experience in terms of running our own businesses, operating at management levels and executive levels within corporations, and in my particular case, even working for a while for a venture capital company. And I might mention that we're also supported here by all of the other business and industry services here at Moore-Norman Technology, and all the specialists there help provide us with assistance as well. So, having said that, we're prepared now to go to questions that you might have for Rob or for myself. We certainly thank you again for listening today, and hope that you learned more than a few things relative to employment law, the basics, and staying out of trouble. Thank you.
Well, thank you so much, Greg and Robert. This was a lot of great information. Both you guys, we've got a few questions coming in, so I want to go ahead and get to those. And like I said, if you have any questions, go ahead and just type those into the box there, the question box. So the first question that's just come in is, when will we see more coordinated efforts between federal laws and Oklahoma state laws regarding ACA compliance for employer mandate by happening this fall?
The question, as I understand it, is when are we going to see more coordinated efforts between the federal government and state government for ACA compliance as we near the deadlines? I think this is kind of casting a crystal ball into the future. I probably see, as far as legislative cooperation, I probably see little. Here in our legislature, is probably going to be bent toward not doing much to coordinate ACA compliance with the federal government. And I think the federal government, at least the legislative branches, are going to be kind of stalled in gridlock on those things. As far as regulatory agencies, I think you're going to see probably the most work is going to be done between regulatory agencies. Obviously, much of the ACA both substantively and procedurally, has been delegated to federal agencies to create regulations and compliance principles, things such as that, and make that happen. Likewise, I would expect, to the extent the state government needs to or feels it needs to do so, what you're going to have is you're going to have state agencies, Department of Human Services et al., things like that, doing the legwork for coordinating laws. The problem you're going to have is you're going to have a continued kind of hostility and butting heads, both between the federal legislature and the federal regulatory agencies and the state legislature and the federal regulatory agencies. So the best thing we're going to be able to do is kind of just pay attention to federal mandates as they may apply to everyone in the country.
Okay, that's great. Another question came in, and I forgot to address this earlier, but about a recording of this webinar. And yes, we have recorded this, and it will be available. Probably have it available by tomorrow, so everybody will get a link to that in the follow-up email. I also wanted to, we haven't got any more questions coming in from attendees, so if you do have questions, please type those in. I know that Greg wanted to address an issue that a client of his had come up that would be a great question that would apply to a lot of our listeners today. Greg, do you want to take that?
Yeah, absolutely. Rob, you had noted in the presentation that the Oklahoma Employment Security Act of 1980 had been updated last year to include the definition of misconduct related for a disqualification for unemployment benefits. So I guess it's kind of a two-part question. Item number one, where would you say would be the best place for employers to find that definition? And then secondly, where the employer is dealing with a hearing examiner relative to a protest of payment of unemployment compensation, and it has to do with misconduct, would it be your advice that indeed the employer should specifically mention to the hearing examiner the word misconduct?
Well, first, as to the second one, as to mentioning the word misconduct, yes, absolutely. What someone contesting an unemployment claim is going to want to do is make it very clear and very forthright. Use the buzzword misconduct. This person was terminated for misconduct. Now, generally, these new laws are going to be found in Title 40 of the Oklahoma statutes. And just to give you kind of a specific laundry list of what misconduct will now include in the Oklahoma Employment Security Act, it's going to include a number of things that either were or were not considered misconduct under common law or OESC internal agency precedent. It's going to include, first, the notion of unexplained absenteeism or tardiness, and I think that's going to be a relaxation of the old standard, which was kind of a yes, excessive absenteeism or tardiness, if it really got bad and there were serial warnings and all sorts of things, that could potentially be misconduct, but that often was a hard thing to establish for the employer. Now the statute says unexplained absenteeism or tardiness. Statute also says willful or wanton indifference to or neglect of the duties required. Willful or wanton breach of any duty required by the employer. The mismanagement of a position of employment by action or inaction. Now, as you can see, as I kind of go down this laundry list, what's being introduced in the definition of misconduct for the first time ever is perhaps the notion of negligence, or maybe gross negligence, as opposed to just, willful wrongdoing. Now we've got concepts of indifference or neglect of duties and mismanagement of duties, things like that. Inaction, inattentiveness, things like that could potentially be misconduct now. And then there are old kind of concepts, actions or omissions that place in jeopardy the health, life, or property of self or others. Dishonesty, which, that kind of was always, if dishonesty was connected to the work and egregious, that was always kind of considered misconduct. Wrongdoing, that's actually a statutory definition now, and talk about much broader than the old law, wrongdoing. Violation of a law, and I think things such as wrongdoing and violation of law are obviously going to have to be connected, in the terms of causation to what it was that got someone terminated for. And then finally, violation of a policy or rule adopted to ensure orderly work or the safety of self or others. Now, what do you do with this laundry list? My thoughts are to take this laundry list, and I've already done this in a number of instances for clients. Take this laundry list and make sure it is in the employee handbook and that it is in some form or fashion distributed to employees, so they will understand now what it is that constitutes misconduct in the workplace. So when you are contesting that unemployment claim, you can say, hey, we not only have these new definitions of misconduct, we have them in our employee handbook, and we have them communicated to employees. Because I think the Employment Security Commission is still going to want to see those definitions in employee handbooks, and they're still going to want to get some sense, even though the statute doesn't necessarily say so, that employees are basically advised of these things that constitute misconduct. So in other words, there's a new laundry list. It's in the statutes now, and get it in your employee handbook.
That's great, Rob. Thank you so much. We've got another good question that came in from an attendee. She's got a question about the employee handbook issue, going back to the employee handbooks you were talking about. She says, we have a regulation on paid time off that I want to make sure is safe. We give our employees 20 days of paid time off, but stipulate that they are not allowed to take more than 7 of those days in a 3-month period. So this is a rolling 3 months. It's not regulated quarterly. And she just wants to know, does this overstep anything where regulating and dictating use of paid time off is concerned?
Generally, that's going to be okay in Oklahoma, as long as you're dealing with Oklahoma employees and it's an Oklahoma company, it's an Oklahoma law. There could be things, say, in some state somewhere that might run afoul of. None come to mind right now. You always got to be careful with California. But generally in Oklahoma, you can define the amount of paid time off, and you have a lot of freedom to say, hey, no more than this much paid time off can be taken consecutively, or you have to give us, sufficient advance notice of your intent to use certain paid time off, things like that. You generally have a general good amount of freedom in Oklahoma to say, okay, here's what we're going to have in the way of a paid time off policy. You have a lot of discretion to fashion that the way you want to.
That's great. Thank you so much, Rob. That's all the questions we have coming in. I think I just wanted to thank everybody for coming today. I think Greg probably has a few words to say just to kind of sum up about the Business Development Center. I really encourage all of you to check this out. Not a lot of people know about this resource that is available to you, but there is so much great stuff there for you if you're a business owner, and they really do want to help. So Greg, if you want to just tell people a little bit about that. Again, I know you did earlier, but just to really invite people to come and check it out.
Yeah, Emily, I'd be glad to. And again, I think the emphasis here is one of scope. We're here at the Business Development Center to serve a myriad of needs and a broad scope in terms of the types of businesses in our district here. If you're an existing business and you have any issues relative to, again, marketing, financing, IT, even things like employment law, we can go to resources like Rob to try to assist us with. If you're a potential new business person, an inventor, et cetera, we can help you with the process of understanding patenting, taking the product to market, et cetera. Or if you have interest in terms of you've got a burgeoning business and need a home, we do have 8 businesses who are resident here at the Business Development Center, and we certainly would like you to inquire as to further qualifications that are necessary here to have your home here and undertake mentorship by us for your new business. So again, as with everybody who's on the line, Appreciate your attendance today, and look forward to helping you in the future. And stay tuned for our next webinar, which is going to be on government contracting, things not to do, sometime probably during the month of July. Thanks.
Fantastic. Well, thanks everybody for attending, and hope everyone has a great afternoon, and we'll get this recording out to you in the next few days.